Well, good afternoon, everybody. Welcome to the FTB Wind Energy Seminar. My name is Andrew Fraser-Urquhart QC. A warm welcome for those of you who've taken a break from enjoying the nicer weather that we've had. All looking forward, I hope, to, fingers crossed, June the 21st for release finally from lockdown. I wonder, though, whether that's really going to be the reality. And so it may well be that we will be working these webinars for a little while longer. Today we are going to be dealing with one or two important aspects of wind energy. We all know how important wind energy is to the future energy mix and for the country's drive towards net zero, and of the Prime Minister's desire to make us the Saudi Arabia of wind power. His possibly, you might say, ideological soulmate, Donald Trump, used to have a phrase at one of his rallies where he would say, "I know a lot about wind. I know a lot about wind." Well, you can judge whether he ever did, but the panel we have today certainly does know a lot about wind. I'd like them, if they can, to come and show themselves on camera just by way of introduction. Good afternoon, everybody. We'll be hearing first from Mark Westmoreland Smith, who's going to talk about the role of cumulative impact assessment, which is one of the fundamental aspects of all wind energy development, but particularly important and interesting in terms of offshore wind. And then we'll hear from Isabella Tafur, who's going to tell us about the offshore transmission network review, which sits very well with the issues raised by cumulative impact. And then we'll hear from Charles Streeten, who is going to tell us about wind farm noise. Again, another seriously important old chestnut, but a very important aspect, again, of any wind energy development. And then finally, and to break away from the concept of people who know a lot about wind, I will tell you one or two practical points about some of the issues raised by the habitat regulations, again, particularly in the context of offshore wind energy developments. So, as I say, a very high-powered panel for you today. And we'll turn first then to Mark Westmoreland Smith. I should say as we go along that we have enabled now a great leap forward for FTB webinars. We've enabled the chat function for you to communicate with one another as the webinar proceeds. But I would ask, please, that if you've got questions, and we of course encourage those, that you can put them on the Q&A function rather than the chat function. Unfortunately, there's a danger of them getting a bit lost in the chat box. So please do save your questions for the Q&A button. Now, turning to Mark Westmoreland Smith, he is rapidly establishing himself as one of the go-to juniors for large infrastructure work. He's already got an extremely impressive record in both wind energy, but all sorts of national infrastructure projects. Very well spoken of in the directories, and with a record that goes back now many years and is extremely impressive. And I'm sure we're going to get a little flavour of that quality in his presentation, as I say, on the important issue of cumulative impact assessment. Mark, good afternoon.
Good afternoon. Thanks, Andrew. Good. Let me try and share my screen. Hopefully that's worked. Good. All right. Well, today I'm, as Andrew's already identified, going to be looking at offshore wind and cumulative impacts. As Andrew's mentioned, Isabella's going to look at the government's offshore transmission network review, which is in part a means of trying to reduce and manage cumulative impacts. And Andrew's also looking at habitats regulations, which of course involves cumulative and in combination effects. And so inevitably there's some overlap in these subject areas. What I want to do, therefore, is just really lay out the problem of cumulative impacts and consider it principally from a point of view of EIA assessment. It's a subject of some importance given the growth of offshore wind and its planned further expansion. On this slide, this is a figure taken from the Offshore Energy Strategic Environmental Assessment, OESEA-4 scoping document, which was published for consultation at the end of March. And it shows the growth in installed capacity in offshore wind between 2003 and 2020. The first offshore wind farm was at Blythe. It was a demonstration project and was installed in 2000 and provided 4 megawatts of power. It's excluded from this graph, but what the graph does show is that in the 20 years or so since the installation of that 4 megawatts at Blythe, over 10 gigawatts has now been constructed, and there is much more to come. In part, this growth has been driven by greater efficiencies and larger turbines, and one can see there the average turbine size indicated over the time period. Blythe consisted of two 2-megawatt Vestas wind turbines with a rotor diameter of 66 meters on monopile foundations in about only 10 meters of water and less than 2 kilometers from the shore. And at that time, those were the largest turbines installed offshore in the world. Well, now things are rather different. Contracts have been placed for MHI Vestas offshore wind 9.5 megawatt turbines, which will be installed in 2021 and 2022 at Triton Knoll and Murray East wind farms. And both MHI Vestas offshore wind and Siemens Gamesa renewable energy have 10 megawatt plus turbines now available. And GE Renewable Energy has just announced that it's got a 12 megawatt plus turbine, which would have a 220 meter diameter rotor. But of course, it's not just the efficiency of turbines, but the number of wind farms is also growing fast. The Climate Change Committee recommendation for offshore wind is an installed capacity of 95 gigawatts as part of achieving net zero. That compares to operational installed capacity of 10.5 gigawatts now. And even with 10.5 gigawatts, the map of current UK offshore maps can appear congested. Sorry, I hope that is now displaying the slide properly. So you see there, I hope, the Climate Change Committee's target of 95 gigawatts. And Isabella's going to show you a number of images in her slides that neatly illustrate some of the congestion down the East Coast, which has numerous projects. And many of the examples that will be touched upon today will be from the East Coast and East Anglia area. And this makes cumulative impacts inevitable and an aspect of the development that must be dealt with. But a curious thing about offshore wind farm technology is that much progress has been made in understanding their potential for electricity generation, and much technical progress has been made in terms of their efficiency and cost. But less progress has perhaps been made in understanding their impacts on the marine environment. As an infinite resource which does not contribute towards carbon emissions, offshore renewable energy is clearly good environmentally and will be essential in our fight against climate change. But at the same time, these projects have the potential to have adverse environmental effects on the marine environment. And so there's a need to balance the need for carbon neutral energy production with the need to protect and preserve existing marine environments. and particularly so in the North Sea, where the consenting of more projects means that cumulative effects on birds and navigation are increasing, as are the impacts of both onshore and subsea cabling. I advised recently in relation to Hornsea 3, where impacts and cumulative impacts on benthic habitats through seabed cabling and on kittiwakes were real concerns. And so it's necessary to ensure that there is adequate assessment of cumulative and in combination assessment impacts in order to prevent developers from having their applications rejected in the future, and to ensure that damaging impacts on the marine environment are not overlooked in the application process. Now, I don't propose to set out the legal requirements for the assessment of cumulative effects in the context of EIA. This is in part because the concept is so familiar, and in part because the detail is so complex. It lies beyond the scope of this talk. The relevant domestic provisions may depend on transitional provisions, the timing of the application in question, the timing of scoping for the application, as well as the nature, size, and location of the project. I think it's sufficient to say that the concept of cumulative impact assessment has been present since the inception of EIA in 1985 and remains an important aspect of the 2011 EIA directive as amended by the 2014 directive. And I set out on the slide Article 5 of the 2011 EIA directive as amended, and that states where an environmental impact assessment is required, the developer shall prepare and submit an environmental impact assessment report, and the information to be provided by the developer shall include at least, and then F, any additional information specified in Annex 4. You go to Annex 4 and paragraph 5 of which states a description of the likely significant effects of the project on the environment resulting from, inter alia, E, the cumulation of effects with other existing and or approved projects, taking into account any existing environmental problems relating to areas of particular environmental importance likely to be affected, or the use of natural resources. So that's where cumulative impacts come in through the EIA assessment regime. But what are the difficulties that arise? And I'm just going to touch on three. The first is the race to the water. This is the concept that it would be beneficial for a developer to be the first to obtain consent for their development, so that they do not need to consider the cumulative and in combination impacts of similar surrounding developments. The first to apply may be able to take advantage of a baseline with fewer developments in it. First come, first serve means that the first developers may have the advantage of having the available environmental capacity to work with. This may have real-world environmental consequences in that the earlier in the rollout, the less knowledgeable and understanding of the impacts of projects on the marine environment, meaning that mitigation measures provided for in earlier projects may not be as effective as they could be. This could potentially mean that projects consented early have greater environmental consequences, and the projects applied for later, which might have better calibrated mitigation and thus be less environmentally damaging, could be refused as a result of in-combination impacts with earlier development. To further fuel the race to the water, the process of funding is competitive. The Contracts for Difference scheme is the government's main mechanism for supporting low carbon electricity generation. Contracts for Difference incentivize investment in renewable energy by providing developers of projects with high upfront costs and long lifetimes with direct protection from volatile wholesale prices. And they protect consumers from paying increased support costs when electricity prices are high. Renewable generators that meet the eligibility criteria can apply for a CFD by submitting what is a form of a sealed bid. And there have been 3 auctions or allocation rounds to date, which have seen a range of different renewable technologies competing directly against each other for a contract. The 4th allocations round is to be held at the end of this year. Successful developers enter into a private law contract with the Low Carbon Contracts Company. Developers are paid a flat index rate for the electricity they produce over a 15-year period, which is the difference between the strike price, a price for electricity reflecting the cost of investing in a particular low carbon technology, and a reference price, the measure of the average market price for electricity. But in order to apply for a CFD, developers need to satisfy the set criteria, and that includes securing the appropriate development consents. This means that developers competing for a single pot of money must get their applications in and determined in time. And that process puts strain on the ability of all involved, including, for example, statutory consultees, who may have numerous applications to assess, to carefully consider the cumulative and in combination effects of a scheme. So the race to the water is a good illustration of the tension between the urgent need for renewable energy generation and combating climate change, and the need to protect the environment. The second potential difficulty is in the use of the Rochdale envelope. Now, the Rochdale envelope is a familiar concept. It allows developers to describe their project using general parameters that cater to uncertainties at the time of the application. It is an essential mechanism to allow an appropriate degree of flexibility to cater for technological advancement, detailed design, and the fact that financing and procurement are dealt with after consent. At its heart, it allows the assessment of environmental effects on a worst case basis. However, this can have a significant impact on cumulative assessments. If numerous developers all apply the worst case approach, the layering up of such scenarios in a cumulative assessment could well produce an unrealistic assessment of the combined environmental impact of the developments. The result of this is that later applications could be refused. The third difficulty is there's a lack, generally speaking, of data sharing. Developers spend a lot of time and money on environmental surveys, and data is generally not pooled and shared. Given the competitive nature of the funding and the upfront expenses, this isn't surprising, but data sharing, in particular in relation to the performance of existing schemes and their mitigation measures, can be important. Such information could have important beneficial effects on future projects and developments. Moreover, without having a detailed understanding of the impact that new offshore renewable technology is having on the marine environment, the assessment of cumulative impacts is made even more difficult. Many gaps remain within the expert understanding of the impacts of wind farms on the marine environment. And a failure to share data that has been collected is likely to extend the time that such gaps exist. I want now just to turn to an example, and that's the Pierce case that related to the Norfolk Vanguard scheme. On the 18th of February of this year, Mr. Justice Holgate quashed the Secretary of State's decision to grant development consent for the Norfolk Vanguard DCA. It's a very sizable wind farm off the coast of Norfolk. The development was closely related to a second wind farm project, Norfolk Boreas, which lies to the northeast of the Vanguard array. And together, the wind farms would have had an export capacity of 3.6 gigawatts. The case concerned the assessment of cumulative onshore landscape and visual impacts at the village of Necton, where the grid connection site for both projects was located, and the Hornsea 3 cable would also land at that location. It was granted development consent on the 31st of December last year, and the Boreas application was at the time due to be decided on the 12th of April this year, but has subsequently been delayed as a result of this case. Mr. Pearce was a local resident, and he argued that cumulative impacts from the onshore project substations for both Vanguard and Boreas needed to be addressed when determining the Vanguard application. And paragraph 4.5, 102 of the EXA's report was key, and I've set it out there on the slide. The EXA said it had not considered cumulative impacts due to the limited amount of details available, and sought to defer consideration to the Boreas examination. And the Secretary of State adopted that approach. The difficulty was that this had been a controversial issue at the examination, and it was never suggested by any party that the details were limited and the issue should be deferred to the Boreas application. Vanguard had carried out a cumulative impact assessment, and the decision makers decided not to take it into account. The judge articulated the essential principle at paragraph 120 of the judgment, and as again I've set it out on the slide, sorry. And the decision maker needs to be satisfied that he or she has sufficient information to evaluate the likely significant environmental effects, and then go on to make that evaluation. But perhaps a critical paragraph of the judgment is paragraph 129, and I set it out there on the slide. Again, I won't read that out for reasons of time, but what the judge said was that a departure from the general principle, which this was, required specific justification. And the Secretary of State's justification for deferring assessment, the limited information available on the Boreas project, was not on the facts of the case lawful or rational, given that the Boreas application relied upon the same information. So the frustrating thing for the applicant in this case is it wasn't the applicant's mistake. It had assessed the cumulative impacts. It was just that the examining authority and then the Secretary of State decided to defer consideration of those effects. So looking at the time, by way of conclusion, cumulative impacts are a real issue in relation to offshore wind farms simply as a result of the number of projects and the government's ambitions in this area. The issues are arising in a world where the 2030 target is for 40 gigawatts, and we currently have 10.5 gigawatts in operation. And cumulative impacts have recently and directly resulted in the delay of both Vanguard and Boreas applications. So although to a certain extent the increasing cumulative effects are inevitable, given the proposed increases in offshore wind energy, consideration needs to be given to a strategic approach. And in part, this is what Isabella is going to be looking at least in relation to cabling. But that strategic approach could be applied to birds, navigations, and other factors. It would need to be done by the government in collaboration with project promoters and nature conservation and marine navigation stakeholders. But just as national policy statements set out needs so that the issue does not need to be returned to on each application, and an overall solution approach could be set out in overarching policy. The danger is without a strategic approach, there will continue to be delays and potentially the frustration of the delivery of the power required to meet net zero. And with that, I will hand back to Andrew. who is currently on mute.
Thank you, Mark. Thank you very much for that, Mark. Very interesting, and certainly pointing up some of the areas where government intervention, government policy might be necessary, actually beyond just the simple planning policy, to take things forward on the scale which is currently envisaged. And speaking to aspects of that, I'll turn now to Isabella Tafur, who's going to speak to us about the Offshore Transmission Network review. Isabella, for those involved in infrastructure, really hardly needs an introduction these days. She has a wealth of experience in nationally significant infrastructure projects in terms of wind energy. We're talking about promoting the Walney extension, objecting to the Thanet extension, involved in East Anglia 1 North and East Anglia 2. Funnily enough, is the way these DCO inquiries take place, particularly in the virtual age. She and I passed like ships in the night, both involved in that case, but I think never necessarily being aware of one another's involvement. Such is life, but unsurprising that she was involved in that. Unsurprising that Planning Magazine lists her as one of the top 10 barristers for infrastructure. So very well placed to tell us about forthcoming developments linking in with cumulative impacts. Isabella.
Thanks very much, Andrew. I'll just share my screen. There we go. Okay. Mark's talk has touched on some of the difficulties and pitfalls in assessing the cumulative impacts of offshore wind projects. My talk focuses not on the assessment, but on the cumulative impacts themselves, and specifically the increasing recognition that greater coordination is going to be needed in order to minimise the social and environmental impacts of offshore wind. And the Offshore Transmission Network Review was launched in July of last year to explore the potential for further coordination. This slide sets out in a nutshell the problem to which the review is directed. So to date, offshore wind farms have been connected to the shore via standalone transmission links. And this approach was designed to minimise delivery risks of offshore wind by leaving project developers in control of building the associated transmission assets to bring the energy on shore. And it was developed when the offshore wind target was 10 gigawatts by 2030, and it's been very successful. But a much more ambitious target is now in place. And in that context, the system of point-to-point or radial connections with cables from each wind farm coming ashore and connecting to substations, which are sometimes many miles inland, is no longer likely to be appropriate. It results in costs, environmental impacts, and disruption to coastal communities, which could be significantly reduced through a more coordinated approach. So the image on this slide is taken from the Phase 1 report on onshore coordination, which was published by National Grid ESO in December of last year. And it shows 3 scenarios based on meeting targets for offshore wind generation by 2050. So the first shows a continuation of the status quo with individual point-to-point connections for each wind farm. And it's readily apparent just how congested the east of England and northeast of Scotland in particular would become in that scenario. The second image shows the position by 2050 if a more coordinated approach is adopted for projects which are anticipated to begin transmission after 2030. And the third shows the position if that coordinated approach is adopted earlier for projects which are due to commence transmission from 2025. So compared to the status quo, that third option would deliver significant environmental and social benefits, as the number of electricity assets, including cables and onshore landing points, could be reduced by around 50%. In the second option, with later coordination, the benefits would be less pronounced, but it could still result in a 30% reduction in assets compared to the status quo. moving from the illustrative to the practical then, I've been working with East Suffolk Council over the last year or so, as Andrew mentioned, on applications by Scottish Power Renewables for the East Anglia 1 North and East Anglia 2 wind farms, which are currently at examination. And as you'll have seen from the map on the previous page, the East Suffolk coast is likely to experience very significant impacts from major energy projects over the next years, as well as those East Anglia wind farms and Sizewell C that are currently at examination. There are a number of other projects coming its way, including 5 Winds Estuary and North Falls wind farms and 2 interconnector projects known as Nautilus and Eurolink. And those projects are likely to have very significant cumulative impacts on the sensitive coastal environment and cause major disruption to local communities. And it's in that context that East Suffolk and other Suffolk authorities have been lobbying the government to take a more coordinated approach to the development of offshore wind. In particular, the Suffolk authorities have been pressing for consideration to be given to an offshore hub to host the onshore substation requirements for those projects in order to minimise the impacts on the rural landscape and local communities. The quotation on that slide is from a letter sent by the Suffolk authorities to BEIS in 2018. And there have been a number of letters along similar lines sent by them to various ministers over the years. And it's been a repeated refrain that Suffolk is due to be inundated with energy projects over the coming years. And while the authorities are supportive of the government's ambitious offshore wind targets, the letters, including the one on the slide, tend to suggest some degree of frustration at the lack of strategic oversight in developing a more coordinated approach in order to achieve those targets. They have, for example, been inviting the government to consider the use of offshore hubs to accommodate these projects. So the concerns raised by East Suffolk and other authorities haven't fallen on deaf ears. In fact, in light of recent and more ambitious targets for offshore wind, there's been a renewed emphasis on the need for a more coordinated approach. And I've set out on this slide a potted timeline of recent developments, which I think illustrates the building momentum on this issue. And I'm just going to spend a moment taking you through those developments because they build upon one another and they explain both the rationale for and the progress towards greater coordination. So the target of net zero 2050 was obviously enshrined in law through an amendment to the Climate Change Act last year. Following that, in February of 2020, Ofgem published its decarbonisation action plan. And one of the actions was to explore options for a more coordinated offshore transmission system to connect offshore wind to the grid. And in the plan, Ofgem said, we don't consider that individual radial offshore transmission links for this amount of offshore generation are likely to be economical, sensible, or acceptable for consumers or local communities. In June of 2020, the Committee on Climate Change prepared a report to Parliament which called on the government to develop a strategy to coordinate interconnectors and offshore networks for wind farms to the onshore network and to bring forward any legislation necessary to enable that coordination. Then in July, BEIS published the review with the aim of ensuring that transmission infrastructure for offshore wind is delivered in the most appropriate way, balancing environmental, social, and economic costs and benefits. The following month, BEIS and Ofgem published a joint open letter inviting stakeholders to identify factors that had inhibited the development of coordinated transmission and to suggest ways to overcome them. Then in November 2020, the government published a 10-point plan for a green revolution, which included that target that Mark's already mentioned of producing 40 gigawatts of offshore wind by 2030. The following month, the Energy White Paper was published, and that included a commitment to implement a more efficient approach to connecting offshore wind projects to the mainland grid. And the White Paper explicitly said that the current regime for connecting offshore wind farms to the onshore grid has encouraged single point-to-point connections, and that the government recognises the impact this is having on the coastal communities which host this infrastructure, and that they will act quickly to take the necessary steps to address the situation. In the same month, BEIS and Ofgem published a response to their earlier joint open letter. And in that response, they noted that several respondents had emphasised the need for the review to clarify how environmental issues of concerns will be addressed before 2030. In particular, stakeholders highlighted the significant impact from projects connecting by 2030 on the coast in East Anglia, and asked the review to address those immediate challenges, for example, through a dedicated case study. One party which had raised those very concerns was East Suffolk Council, which sought clarification on how the review would interact with the examination of the East Anglia wind farms and whether the timing of their examination would or should be affected by that review. In December, National Grid ESO published the Phase 1 report on offshore coordination, which was really the first step pursuant to the review that was launched in July. And one of the factors that had come through in an earlier consultation carried out by National Grid before this report was the fact that achieving coordination for projects that were likely to be delivered from 2025 would be extremely challenging and would potentially risk the 2030 target of 40 gigawatts. And the reason for that is because it usually takes between 8 and 12 years to develop an offshore wind project. And connection configurations are usually identified at an early stage in that process, which means that those projects that are due to connect before 2030 will already be partway through their project development. And if there were to be fundamental changes to their design or connection configuration, that would be likely to set them back several years, which could in turn threaten progress towards the 2030 targets. And so that stage 1 report recognises that the benefits of early coordination will need to be balanced against the risks of delay. The last stage to date was the publication in April of this year of the East Coast Grid Spatial Strategy, which was commissioned by the Crown Estate in partnership with the MMO, National Grid Electricity Transmission and National Grid ESO. And that document explores constraints to radial connections along the east coast of England, the risks which those constraints pose to the delivery of offshore wind, and whether a more coordinated approach could reduce those risks. And in terms of the potential for a more coordinated approach, it considered a number of options, including offshore hubs where multiple wind farms would connect to a single hub, which would then be connected to the grid onshore via a single export cable route. Or as another option was an onshore coordinated scenario where the existing onshore transmission system would be extended closer to the coastal areas so that while radial connections would still be used, you would avoid the need for additional cable corridors extending further inland. That report includes a number of recommendations, including a review of the existing planning and marine licensing regimes, and potential updates to marine plans and national policy statements to provide a supportive policy framework for a more coordinated approach. Further consideration of who would be responsible for the development and operation of coordinated infrastructure, and also the identification of an offshore wind farm developments that might provide an opportunity to pilot a coordinated grid connection. So the key points of the review I've set out on this slide. The launch of the review wasn't really the start of this process, and it certainly isn't the end of it, but it does provide a clear statement of the government's recognition of the problems posed by the existing regime. The review's terms of reference expressly say that in the context of increasingly ambitious targets, constructing individual point-to-point connections may not be the most efficient approach and could become a major barrier to delivery. Second point is that the review isn't so much a single document or even output from a single organisation as a forum to bring together the key stakeholders who were involved in the timing, siting, design, consenting and delivery of offshore wind. And as is apparent from the collaboration and the various joint publications that I've touched upon, a number of agencies are clearly working together towards a common goal now. The main work streams then, these are set out in the BEIS Ofgem letter of December 2020, and they cover 4 areas. The first is the early opportunities, and this work stream aims to identify projects which could be coordinated using flexibility in the existing regime or by making small changes to current processes. And the emphasis here will be on voluntary opt-in from developers who want to become pathfinders. Realistically, I understand from a very useful webinar that BEIS coordinated in December that they'll be targeting projects for this early opportunities that are aiming for the round 5 CFD auctions in 2023, because those are projects which still may be able to make some changes to allow for greater coordination before putting together their bids. So the second work stream is Pathway to 2030, which will target projects aiming to connect in the late 2020s and early 2030s, and could include projects coming through the Crown Estate's round 4 leasing. And the aim here will be to increase central coordination and accelerate the delivery of the necessary onshore and offshore infrastructure to facilitate greater coordination. And the third work stream is to develop a new enduring regime from 2030. All key aspects of the existing regime could be subject to change here, including the approach to leasing and consenting offshore wind. And this is likely to require changes to primary legislation in a new energy bill, as well as changes to national policy. And the fourth work stream I put for completeness, it relates to multi-purpose interconnectors, but I'm not going to dwell on that today. The final key point, and one of the themes that comes out strongly from the National Grid Phase 1 report, is the tension between the overwhelming support for greater coordination and the need to ensure that existing projects can continue without unreasonable disruption and delay. The response in the Phase 1 report appears to be a recognition that the earlier intention to work towards coordination from 2025 is no longer seen to be as realistic. And as I say, the focus for projects currently in the pipeline will be for optional buy-in from developers. The difficulty with that approach, of course, is that it doesn't particularly assist those areas which are likely to see considerable pressure from new offshore projects before 2030. And I think that tension is borne out by experience of offshore wind farms which have recently or are currently going through examination. And I've just picked up on 3 examples. So in the Hornsey 3 examiner's report, the potential for an offshore connection was raised by interested parties, but it was given very short shrift by the examining authority. They just said that wasn't an alternative that had been considered by the applicant. They didn't have any information. And they couldn't comment on its merits or consider it any further. It's fair to say the Secretary of State's decision, which came out in December 2020, so after the review had been launched, did engage a bit more substantively with suggestions. And he noted the possibility and discussions around an offshore ring main, but he pointed to existing policy in the National Policy Statement EN3, which says that when considering grid connections, the decision maker should be mindful of the constraints of the regulatory regime for offshore transmission. So given the development had been brought forward in line with the existing regulatory regime, the Secretary of State didn't consider there was any justification to delay his decision pending any outcome of the review. In the Norfolk Vanguard report, the examining authority found that the possibility of an offshore ring main was a strategic matter which involved coordination between many layers of interested organisations and between multiple projects, and wasn't suitable for consideration in a forum which was considering a DCO application by a single developer. But it did invite the Secretary of State to note the strongly held views in light of the number of offshore wind farm projects coming forward in the region, that there should be a strategic approach in terms of the development of an offshore ring main. And in his decision, the Secretary of State effectively pointed again to that part of EN3 I've mentioned. And he said that there were discussions ongoing about the future shape of offshore transmission, but those discussions were at a preliminary stage and his decision shouldn't be delayed to await its outcome. That reasoning might suggest that as the review progresses beyond its preliminary stages, the weight it's attributed in individual DCO applications could increase. Certainly Section 104 of the Planning Act requires the Secretary of State to take account of matters he considers to be important and relevant, which could include the findings of the review. But it also requires applications to be determined in accordance with the relevant MPS, other than in certain fairly limited circumstances. And given that the MPS effectively says, you have to be mindful of the constraints of the existing regulatory regime, it's difficult to see how the findings of the review could justify a refusal of consent, say, for an offshore wind farm, which was in accordance with the existing regime. Just to complete the Norfolk Vanguard story, Mark has touched on the successful challenge by Mr. Pearce, but in fact, in his pre-application correspondence before that successful challenge, Mr. Pearce raised another potential ground of challenge, which was the alleged failure by the Secretary of State to take account of a reasonable alternative to the Norfolk Vanguard scheme, namely the possibility of an offshore ring main, which he said should have been assessed. In response, the Secretary of State and Norfolk Vanguard argued that the offshore ring main was too vague and at too preliminary a stage to be treated as a reasonable alternative. Ultimately, that ground wasn't pursued in the High Court, but Mr. Justice Holgate did raise a judicial eyebrow at the examining authority's suggestion that the possibility of an offshore ring main could be discounted because it would require coordination between projects. He didn't seem very convinced by that reasoning. Since then, in April of this year, BEIS has published a letter requesting further information to inform the Secretary of State's redetermination of the Quash decision. And I understand that certain responses to that consultation have again made the case for an offshore transmission network. And in light of the government's review, it's been said by certain consultees that the case for an offshore ring main is now stronger than ever and should be considered and assessed as a reasonable alternative. The deadline for responding to that consultation has been extended to the end of this month, so we don't yet know how that suggestion will be treated in the redetermination. Very briefly on East Anglia 1 and 2, the authorities there, in their submissions to the examining authority, have taken a pragmatic approach of expressing some concern that there haven't been amendments to the national policy statements following net zero 2050, and they have raised some concerns about the inability to integrate those examinations with the ongoing review and the findings of the review. But they've recognised that given the relative timescales of the progress of these DCO applications and the review, it's unlikely to be feasible to secure greater coordination as part of those applications. So, key messages in summary: change is afoot in the way that offshore wind farms connect to the grid. Those changes are unlikely to be felt on the ground until the mid-2020s at the earliest. And even as the review progresses, I think its findings are unlikely to derail the progress of DCO applications that are currently in the system, or even those not yet in the system but aiming to connect prior to 2030. This is likely to be frustrating for host authorities and local communities because they'll see the direction of travel, but they'll be unable to use it to affect any actual change to projects over the coming years. And I imagine that examining authorities will be at the sharp end of hearing about those frustrations. But having said that, energy operators, host authorities and other stakeholders do have the opportunity to influence the shape of the new regime. Ofgem is expecting to consult later this year on regulatory change, which could be made as part of the early opportunities workstream. And BEIS also intends to consult this year on key areas of change for the enduring regime. So those with an interest in the approach to connecting offshore wind should take advantage of those opportunities and make their voices heard. Thank you.
Isabella, thank you very much indeed. Absolutely fascinating glimpse into what may be happening in the future. I'll turn now to Charles Streeten. Good afternoon, Charles. Charles is already establishing himself in the relatively few years he's been at the bar as a leading junior in all sorts of public law work, but particularly environmental work. He's ranked by both Legal 500 and Chambers and Partners, which at his tender years is quite an achievement. He's been in the Court of Appeal, he tells me, 5 times already this year, which is quite disgusting, frankly, and shows really what a talented junior he is. And he's very well versed in renewables and wind energy, picking, I suspect, this topic as part of his involvement in the Greencoat litigation, where he defended one of the UK's largest renewable funds in a nuisance trial involving noise nuisance. And he tells me that he achieved the advocate's greatest triumph of all, which was to have the prosecution withdrawn following his cross-examination of the prosecution's witnesses. So that just gives you a measure of the man. Charles, good afternoon. Tell us about wind farm noise, please.
Thank you very much indeed, Andrew. Yeah, I think we're probably turning from hot air to white noise now. And in particular, we're going to talk about the noise that wind farms make and the planning and nuisance consequences of that. As Andrew said, I dealt with the Greencoat litigation, which is ongoing. If you want an example of why to make sure you do things right following that, there's been a wasted cost application against the solicitors and leading counsel on the other side in the sum of £500,000, and that's ongoing, so I'll be a bit circumspect about what I say. But this is still very much current before the courts, noise nuisance arising from wind farms, and so it's that I'm going to talk about. I want to start by just summarising the thrust of what I'm going to say, and I'll do some nuts and bolts at the very beginning, which is probably boring and teaching my grandmother to suck eggs, but I just want to make sure everyone understands what I'm talking about. Then I'll look at the applicable guidance, and then the 2 kind of key areas for practitioners. Firstly, planning for wind farm noise, and finally, wind farms and noise nuisance. So dealing with the nuts and bolts, quite literally, I put on this slide a diagram of a wind turbine. And in terms of noise, there are 2 key aspects. One are the blades, which make a noise because they create air pressure when they turn. And in particular, the nature of their turning creates what's called amplitude modulation. That might be called blade swish more commonly. And then also there's the nacelle that contains a generator and a gearbox, which create mechanical noise. That's less frequently a problem in nuisance cases, but the combined effect of the 2 is what one tends to hear when one hears a wind farm. And different people describe it in different ways, but sometimes it sounds a bit like an aeroplane is approaching and never passing. It's described sometimes as a roar, sometimes as a whomp, sometimes as a swish. In terms of making that a more scientific consideration, there are a series of different ways in which noise can be measured and calibrated. We all understand the concept of decibels, which measure pressure, but it's important to understand that there are different ways of looking at that pressure. So firstly, one tends to weight the pressure, and that's what the A stands for when you see dBA. It means that you're essentially changing the way in which you look at the pressure to accommodate the way in which the human ear hears that pressure. And then you can manipulate the figure in a number of ways. So you can average the figure over a period of time. That would be what's called LAEQ, or LDEN, that's averaging across day, evening, and night. Or you can look at the maximum level of pressure, the highest possible decibel level within a time period. That's your LA max. And finally, you can look at percentages. So you could have an LA 90, which is the level exceeded 90% of the time, or an LA 10, that's level exceeded 10% of the time. And it's by using all of those different statistical measures that one is able to get a scientific understanding of the nature of the pressure as experienced by the ordinary person, which is what one really is looking for. But noise is more than just decibels and pressure in and of itself. It's commonly recognized that noise is annoying because of particular aspects of the way that you hear it, rather than just how loud it is. So you think about someone scratching their fingernails down a blackboard. That's not just how loud it is, it's the nature of the noise which causes irritation. So there are really four things that you look for when you consider noise. The first are tonal components, often described in terms of frequency. So essentially what you do is you break down the noise into different frequency bands, and you look to see whether there are particular levels of concentration, so particular pressures of frequency that protrude above the other noises and that you hear differently. You might look for impulsive components, bangs, clicks, clatters and thumps. Those are rare in wind farm cases, and if you do hear them, there's probably something mechanically wrong with the wind farm. Then there's amplitude modulation. This is the big one often these days in wind farm noise, and the reason for that is that it's not really covered by any substantive extant guidance, and it has therefore become the battleground between objectors and claimants and promoters and operators. And then finally, there's low frequency noise. So particular tonal components below 200 hertz are going to be heard more dominantly than those above 200 hertz. Then that's a low frequency noise, whereas the opposite would not be low frequency. And I suppose if you think about hearing the bass from a big festival or a music event, that's what you're hearing there. That's that low frequency noise. And ultimately what one has to do is to form a judgment, putting all of those different components together, both the decibel level, the pressure overall, and all of its components, tonal, modulation, and so forth, and form a judgment on its reasonableness contextually, whether or not you're predicting for a consent or you're defending a scheme which has been built out and is in operation. And it's for that reason that there's some pretty detailed guidance on how one looks at wind farm noise. And there are two key policy documents, I think, to be aware of in terms of the guidance on wind farm noise. The main one is ETSU R97, entitled The Assessment and Rating of Noise from Wind Farms. That's based on the British standard, which deals with the general kind of approach to noise from commercial and mechanical producers, but it refines that in the context of wind farms specifically. And what it does is essentially compare turbine noise with a level 5 decibels above the background noise. So what's acceptable is relative to the character of the noise character of the area, because you consider the background level, but there is also a lower limit if you're in a quieter area. One of the things that's interesting about ETSU R97, and it's something that's often criticised by local residents, is that the nighttime lower limit is significantly above the daytime limit. And I think the reason for that is that people generally are not considered to be out in their garden enjoying themselves in the middle of the night, whereas they are during the day. And so you get the mitigation and the attenuation that result from it transmitting into a building at night, and therefore there's actually a higher nighttime noise level than a daytime noise level. There's also a sliding scale of penalty for tonal noise, but amplitude modulation is not itself fully covered. And so that, as we'll come on to see, has become, as I've already said, the battleground. Also worth being aware, because ETSU R97 is quite an old document, that the WHO most up-to-date publication is its Environmental Noise Guidelines for the European region, published in 2018. Those set 45 decibel LDEN, but it's important to be clear that that is what it is. It's an average across daytime, evening and night. And the purpose of the 45 decibel limit is that it takes into account all of the variation across a year, including shutdown periods, low wind speeds and upwind propagation. So if someone, particularly if you've got an uninformed objector, is seeking to rely on that 45 decibel limit, it's really important to make sure you understand what it is actually that's being talked about. Because as we saw at the beginning, the different ways of averaging can make very different, or can have very different consequences for how you actually understand what the words mean. This then is the difficult one in terms of reconciling individuals and objectors with the renewables and green energy movement, it's amplitude modulation. Now, what that essentially means is the difference between the top and the bottom of the graph on the left-hand side of the slide, and it's what's heard as a whomp or a swoosh, because it's the difference between the air being pushed and there being no air. So it's the impulsive tone that comes woof, woof, woof as the turbine comes through. And a lot of people will say that that's the most irritating aspect of wind farm noise. It's also the hardest to take into account when you're considering the reasonableness of the noise created by a wind farm. It's the one which is not covered by any extent a kind of adopted guidance, and therefore it, as I say, is where people tend to have the biggest fights. There is a publication produced by the Institute of Acoustics, which is the recognized professional association for acousticians, entitled The Method for Rating Amplitude Modulation in Wind Turbine Noise. That does not set any prescriptive level of amplitude modulation. It does, however, prescribe a number of different features of amplitude modulation and how people react to those. So the first one is that it's a 2 decibel peak to trough value, top to the bottom of the graph, that people tend to start noticing the sound of the amplitude modulation of the whomp of the turbine blade passing. The second is that what's normal is generally considered to be in the 2 to 6 decibel range. That's your average peak to trough value. So if you are litigating over this, particularly in a nuisance context, and you're seeking to assert that you are the reasonable user of the land, when you start getting above the range of 2 to 6 is when you start moving into more difficult territory, because anything above 6 is regarded as being excessive. That is not to say that anything below 6 is unirritating. Indeed, what the IOA publication says is that anything above 3 decibels should look to be reduced in depth or the frequency of its occurrence, and a penalty needs to be applied to the overall decibel average used for amplitude modulation in circumstances where you have more than a 3 decibel peak to trough variation. That guidance by the Institute of Acoustics has been approved by what was then DEC in the Wind Turbine Amplitude Modulation Review. But it's fair to say that it was unpopular. And so the Independent Noise Working Group commissioned a study which entitled Amplitude Modulation and Planning Control. Now, it's worth noting that much as if you find a country with the word democratic in its title, it's often very much the opposite. Where you find an action group with the word independent in the title, it's also very often the opposite. The Independent Noise Working Group is in fact really, I think, fairly described as being an aspect of the anti-wind or at least anti-onshore wind lobby. It was sponsored by Chris Heaton-Harris MP and the National Alliance of Wind Farm Action Groups, so very much the objection leading individuals and groups that commissioned and sponsored the report. And its express objective is to protect communities and wind turbine neighbours from amplitude modulation. So its whole purpose is essentially to seek to reduce or prevent amplitude modulation, which is an inevitable part of wind farm noise. That's rather different from ETSU R97, which expressly recognises the importance of balancing the interests of individuals and communities affected and the general generation of green energy through onshore wind. In light of all of that, what happens when you actually get on the ground? How are these things considered at planning inquiry or at DCO examination in the first instance, and then if you've built out and then have an objection at trial? Well, dealing first with planning, the framework is suitably vague on noise, and what it seeks to do is prevent unacceptable levels of noise pollution. That's essentially all the framework says on the question of noise. But the PPG is clear that noise can in and of itself be a reason to refuse planning permission. And so there are 3 important concepts when one applies the guidance that we've just looked at in relation to wind farm noise. One is significant observable adverse effects. The other is essentially the level at which adverse effects begin to be felt, and the final is the level at which there are no effects whatsoever on the health or quality of life. So that's SOL, LOL, and NOL. And what the planning practice guidance makes clear is that in decision taking, you need to avoid significant adverse effects. And then you need to consider whether or not there's an adverse effect that's likely to occur. And finally, whether or not a good standard of amenity can be achieved. And if you've got a significant adverse effect on health and the quality of life, then that is likely to be something of a showstopper point. But if there is simply an adverse effect on health or the quality of life, then that's a planning harm to go into the balance. And if there's no effect whatsoever on either health, the quality of life, or amenity, then noise is not something you need to worry about. Generally speaking, the way in which noise is going to end up being dealt with in any planning context, be it major infrastructure or a planning application, is through condition, and there are now fairly well defined conditions. In some instances, amplitude modulation conditions have been imposed, but not in all instances. And so that, again, even in the planning context, remains the battleground. What about if you get your consent and you build out your scheme and you start operating it, and those people who objected then seek to bring a cause of action against you? That cause of action will be in nuisance, and as we'll come on to see, there are multiple forums in which it can be brought. But I do think it's just worth remembering what the key features of the law of nuisance are, because I think there's a tendency, not just amongst the people affected by wind farms, but also sometimes the people who advise them, to see an impact upon amenity and some level of harm to quality of life as automatically constituting a nuisance. They think it's an interference with enjoyment of land, and that sort of is nuisance 101. But the key point, and it's a point which the Master of the Rolls made very clear in the Network Rail case, is that nuisance is all about reasonableness. It's not just about interference. And of course, we all know from our first day, more or less, at law school, that what's reasonable is contextual. So what would be a nuisance in Belgrave Square is not a nuisance in Bermondsey. Those are two very different places. They're two very different contexts, and therefore what's reasonable in each of them is different. That is particularly important when you look at wind noise, because it's accepted, and it was accepted by the Supreme Court, specifically Lord Sumption, that there is a need for individuals to be the subject of consequences of activities which contribute to the ordinary life of a modern community and which need to be accommodated. And wind power generation is a classic example of that. It is something which it is in the wider societal good to be able to provide. So if the context is one which is broadly suitable for a wind farm, which is broadly characteristic of a location where wind farms have been found in a number of instances to be acceptable, then that's very much going to be a more difficult case for an objector, because they're not going to be able to say that it's an unreasonable place to be putting a wind farm, and they're going to have to accept that to some degree the greater good, as it were, means they need to be subject to the consequences of a wind farm being present. Again, it's worth noting, and this is the fourth point on the slide, that we're not concerned in the context of nuisance simply with audibility or even irritation. Leaving aside the context of hypersensitivity, so somebody who turned up to the planning inquiry or turned up to the DCO examination, very much objected to it, had their objection dismissed, and therefore cannot help but hear the wind farm because it has dominated their life for 5 years before they even turned up. Even someone who, say, moves into the area but finds a wind farm irritating is nevertheless someone who has to bear in mind that nuisance is not about that. It's about whether there's a level of disturbance going beyond what's ordinarily acceptable. And indeed, in a case called Budd, the court made clear that there's a continuum, and really at the point where you're finding a nuisance must be the point where you regard something as being so irritating that it's intolerable and indeed positively criminal if it affects a large enough number of people. So that's got to be the level. It's got to be intolerability rather than simply irritation. Finally, and this is something which if you're advising promoters and operators of wind assets, it can be difficult to explain. Although planning permission is, of course, relevant to nuisance, and it's relevant in 3 ways. It can change the character of the area, it can provide evidence regarding the importance of the activity, or if you're operating in accordance with a condition, the Supreme Court said it can provide a useful benchmark or starting point to consider what's reasonable in terms of noise. But notwithstanding all of that, it is not determinative of the question of whether or not a use is reasonable, and it is not determinative of whether or not there is a nuisance. And so you need to be mindful that merely complying with a planning condition, although it may be strongly probative of not causing a nuisance, does not in and of itself mean that there's no nuisance caused. And indeed, in the case that I was talking about earlier with Andrew, the Greencoat case, there was no amplitude modulation condition on the planning permission. In fact, the inspector's report had specifically said, if there's a problem with amplitude modulation, that can be left over and dealt with through the nuisance regime. And so relying on the planning permission as a sole means of defeating that would not have been successful. That then leads me to the final points that I want to deal with, which are the kind of practical points in relation to how nuisance actions will find their way into the court. The first way, and perhaps the least likely when you're dealing with a wind farm, is that the local authority could itself serve an abatement notice. That's unlikely because it will tend to be that local authority which is itself granted planning permission. It may have been on appeal to the Secretary of State, but then it would have been the losing party at the inquiry on the call-in or recovered appeal. And so generally speaking, local authorities do not serve abatement notices against wind farms. If they do, you can appeal the notice to the magistrates court. Best practical means is undoubtedly a defence, and costs don't follow the event. It's to the civil standard of proof. That's not to say that you can't get costs if you succeed on an appeal, but what you would need to show is unreasonable conduct by the authority who has served the notice. And I've been involved in one case where the court essentially said that it was a notice that should never have been served and awarded costs against the local authority. The second, and perhaps the most prevalent means of these cases coming to court, are private prosecutions under Section 82 of the Environmental Protection Act 1990. It's fair to say that what is supposed to be a simple procedure that is accessible to ordinary people has become quite the opposite, partly because of the drafting of the legislation and partly because of the commercial nature of the activities that are being attacked. They're heard in the magistrates' court, but as I said in the beginning, the case that I was involved in, the Greencoat litigation, had a bill of costs on both sides into 6 figures. So it's not ordinary magistrates' court litigation at all. The defendant, and there's often some confusion about this, is the person responsible for the nuisance. And of course, there could be more than one person responsible, and you could then have multiple defendants. If you cannot find the person responsible, then it's the owner or occupier of the land. And sometimes I think there's a bit of a kind of tail chasing exercise where people are concerned to work out who the appropriate defendant is. But my own view is, if you're to bring such a prosecution, then as long as you meet the test in the Code for Crown Prosecutors for all of the individuals as either the person responsible or the owner occupier, because you can't identify the person responsible, you should go against everybody and let people cut each other's throats in court. Perhaps the most important thing to remember about Section 82 is that notwithstanding the way the legislation is drafted, the court has made it extremely clear that it is a criminal prosecution, which means the criminal burden of standard of proof applies as to the criminal procedure rules. That raises all sorts of issues around the admissibility of evidence, in particular in relation to hearsay and bad character. And for a defendant, you can run something of a muck if you have a tight procedural ship against someone prosecuting who does not know what they're doing. That then causes further embarrassment further down the line, because private prosecutions need to be run to the highest possible standards. As the courts have made clear, it's an individual taking upon themselves essentially the burden of the state to accuse somebody of a criminal offence. The most, in my view, important aspect of that criminal regime is that because these are summary offences, the Section 127 of the Magistrates Court Act essentially puts a 6-month limitation period on bringing an action. The effect of that is that if you want to rely on anything that's happened outside that 6-month limitation period, you're going to need to apply to reduce bad character. And amongst the things that happened in the Greencoat case were a number of experts' reports were served, which related to historic noise levels. All of those were excluded on the first day of trial because no bad character application was made and because all of the data that they relied on was not from within the relevant 6-month period. So that's something to be really cautious about. In terms of remedy, you're looking at an abatement order and compensation should you seek it under Section 35 of the Powers of Criminal Courts Act. And costs will be under the Prosecution of Offences Act 1985, which essentially means either you get them at legal aid rates, if you get them at all, depending on the nature of the defendant, or you're looking at wasted costs or cost thrown away applications, the tests for which are extremely high. Those would be applications against the lawyers themselves or for the unreasonable conduct by the litigant. Very difficult tests indeed to meet. Finally, then you can go in common law nuisance. These are rare in terms of wind farm cases because of the availability of actions under the 1990 Act, but you do get cases in the county and high court relating to wind farms. The civil burden of proof and standard of proof applies. The remedy is injunction, although in reality with a wind farm, you're almost always going to be looking at damages in lieu of that injunction. And of course, one benefit in that forum is that costs follow the event. Thank you very much. That's my whistle-stop tour of noise in relation to wind farms, and I will hand you back to the capable hands of Andrew.
Charles, thank you very much. Good. Well, we're running a little over time, so I shall try and keep my contribution as succinct as I am able, which may not be great. Let me just get the slides up for you. Right. Well, good afternoon, everybody, formally from me. I'm going to talk about a couple of discrete areas of the Habitats Regs regime, and but areas which are of particular importance, I think, at a practical level to wind farm applications, and particularly in the offshore context. And those are these. The first is, how does one deal with the assessment of an adverse effect by disturbance? And obviously one deals with this primarily in the context of birds, and really asking the question of, is it a matter of referencing effects on the population that is protected within an SPA, or is it a consideration effectively of as an effect on habitat? And then that links in to the second issue, which I want to touch upon, which I know again is a live issue for offshore operation in particular, which is the issue of whether or not there's a concept of de minimis when considering issues of habitat loss and damage in the context again of SPAs and European sites. Plunging in to the basics, as I put it, of course, I'm sure we're all pretty familiar with this, so I won't dwell much on it. And I'm going to take my references from the offshore habitat regs, but the onshore ones are much the same in terms of concepts. And Regulation 28 is really where the meat of it is, the familiar two-stage test. First of all, is there likely to be a significant effect on the European site, one way or to other, adverse or positive? And if there is, then one has to move to appropriate assessment. And importantly, just noting the words that the appropriate assessment has to be undertaken in view of the site's conservation objectives. And then obviously, if there is an adverse effect on the integrity of the site, then you don't get permission unless you can establish IROPI, which isn't particularly easy. Again, just worth reminding ourselves that the European Court's now very clear that the standard of testing is based on the best scientific knowledge in the field. The Holohan case providing a nice reference to that. And again, also reminding ourselves that we look first now at domestic law, the domestic regulations, albeit they are a transposition of European directives, but we go first to domestic law. But as things stand, even post-Brexit, European Court decisions are still relevant. And of course, many of the fundamental guiding principles still found in European Court of Justice cases. So there's the basics. Again, I'm sure very familiar to everybody. So turning to the first of my two little issues, what's the correct approach? Effectively, if a bird species is displaced by disturbance from turbines away from a particular part of an SPA, that's in the cases where the turbines themselves are located within the SPA, or indeed on occasions where they're located close to the SPA, the issue can still arise. So this is not the direct impact of the turbines on birds, the occasional collisions that one sees. And I can't mention this topic without remembering perhaps the most horrific thing I ever saw at a planning inquiry some years ago now, down in the Isle of Wight, doing an onshore inquiry, and some objectors produced a video of a bird of prey circling around a turbine, and every time the blades came down you winced because you knew what was going to eventually happen. But this video went on for an indecent length of time, and I don't think I've gritted my teeth so firmly ever in an inquiry. And eventually, of course, the inevitable did happen, and there was the splattering of the bird. But every time the turbines came down, I winced, and I still remember that very vividly. A thoroughly unpleasant piece of presentation. But anyway, we're not talking about that, thankfully. We're talking about the disturbance of birds away from a particular area. And in that context, how do you assess the impact of that effect on the integrity of the European site, effectively habitat loss or a matter based on population? Now, there clearly is a distinction between disturbance and loss of habitat. And what one can argue with some force, I think, is that the habitat itself remains. There's no physical impact on the habitat, and so one can argue that the extent of the habitat is unaffected, and what you're getting is a dynamic redistribution of birds within the SPA, or even possibly some birds will choose to use areas outside the SPA. But the central point for argument and the central point for evidence and assessment is that the habitat remains, and the extent in this particular scenario is unaffected. And that leads on to the framework for consideration of relevant case law. Now, the first case to consider in this context is the Sweetman case. This is important also, and I'm going to come back to it in some detail when looking at de minimis. But it plays into this scenario too. The Loch Corrib special protection area in the Republic of Ireland had a proposed bypass through it. Now, the site had been designated as a site hosting a priority habitat type, which was limestone pavement, and that was specifically listed for protection in Annex 1 as a priority habitat type. And a very small percentage of it was to be lost. 1.5 hectares out of the 270 hectares of limestone pavement was actually going to be permanently destroyed by this bypass road. And that was held to be sufficient to constitute an adverse impact on integrity. And we'll look in a little more detail later at the reasons why. But it was held to be an adverse impact, even though the percentage, if you do the maths, is somewhere around less than half of 1% of the limestone pavement was lost. Still enough to be an adverse impact on integrity. The other case which comes up a deal in the context of these arguments is the Grace and Sweetman case. Grace, as I'll refer to it from now on for distinctions, another SPA in the Republic of Ireland. And the conservation objective there was to maintain or restore the favourable conservation condition of the hen harrier birds. Development was a wind farm. Now, what the court held on that occasion was that there was a permanent and direct loss of part of the foraging habitat, as well as a temporary loss of another part. But it's important again to note that this is a case where the court was persuaded on the evidence that there would be a permanent and direct loss due to the extent of impact, admittedly by disturbance, but the extent of impact on the habitat. Now, this is an onshore case, which may be of some relevance because the nature of onshore effects possibly more variable within a given area than at sea. But in this event, the courts was directed to evidence that there was in fact going to be a permanent loss of habitat, and that was the framework through which this case was decided, and an adverse effect on integrity was determined on the back of that. Now, I said when introducing the statutory words that the appropriate assessment had to be undertaken in view of the conservation objectives of the site. And just to develop this argument and see where things go with a real example, I've picked up on the Outer Thames SPA. That was of some relevance, as many of you will know, in the East Anglia wind farm cases, which were still being considered on under delayed DCO examination at the moment. But that was the relevant SPA, and these are the objectives. And points to note from the stated objectives is, first of all, the site contributing to achieving the aims of the Wild Birds Directive, and that's the central, as it were, overall objective. And then these 5 sub headings almost of objective, including the distribution of the habitats, the function, structure of habitats, and then the populations of each of the qualifying features, obviously being particular species of birds, and then the distribution of those qualifying features within the site. And so that's the basis of consideration in view of those conservation objectives. And then one turns to look for a definition of integrity, and those can be usefully drawn from Sweetman and Grace, Grace providing a slightly more extensive list of objectives. And they can be summarized perhaps as the lasting preservation of the constitutive characteristics of the site of the habitat in that area, the survival of the species in question, and its reproduction. And so integrity, clearly a broad and relatively hard to define concept, but nevertheless involving those elements, and the elements involving both habitat and survival of species. And so then moving on to take up other aspects of the conservation objectives, the Wild Birds Directive, very much focused, as perhaps one might expect given its title and its nature, towards population. And so requisite measures to maintain the population of the species, that's what comes from Article 2. Then from Article 4, again, special conservation measures in order to ensure the survival and reproduction of the populations. And that's in turn what leads to the policy imperative in the directive to designate special protection areas in the first place. And so pulling all of that together when looking at these disturbance cases, there is a very strong argument that the way to do it, and that you can focus properly upon not looking at it as some form of habitat loss case, but to focus on the overall population. That's very much a matter of scale and evidence. But the practical consequence of all this, I think, is that if your evidence can show, as a developer, a promoter, that the effect on the overall population of the relevant species within the SPA is not going to be affected to any material degree, any significant degree, then it becomes irrelevant for the purposes of considering integrity whether or not the birds are disturbed and, as it were, redistributed within or even possibly without the SPA. But it is a matter of scale, it is a matter of evidence, and it's something that needs to be threaded quite carefully if you're going to make this kind of argument, because there are cases. There's a particular Scottish case which is something of a fly in the ointment for this analysis, which was a case involving golden eagles and a wind farm, and the judge there decided to hold that this purely by disturbance was a habitat loss, and therefore the issues about de minimis, which we're about to consider, came into play. Bagmore Wind is a very unsatisfactory case. One might even go so far as to say that neither the inspector nor the judge necessarily really understood the real nitty-gritty of the arguments being put to them. That's perhaps slightly disrespectful, but has to be said. But the conclusion really to draw from this is that if the evidence can demonstrate that there is an absence of significant effect on the population, then that's the right way to characterize disturbance cases and not as a habitat loss type issue. Second issue then, and I'm just keeping my eye firmly on the clock, the issue of whether or not, when one deals with a physical loss of habitat scenario, whether or not there is a de minimis concept, i.e. if there's some really teeny tiny loss of protected habitat, whether that can escape either appropriate assessment or can simply be passed after an appropriate assessment. And the reason perhaps that the consideration arises, it's not mentioned in any of the legislative provisions surrounding this area. And there's been of late a much tighter approach by statutory bodies about this issue, partly triggered by some of the language in Sweetman, which we'll come on to in a moment. There is a MMO guidance note which talks about the uncompromising language used in Sweetman and says in terms that they don't think there's scope to apply any form of de minimis rule for loss of habitat, meaning that you'll need to fall back on IROPI if there's any loss of protected habitat. And if one goes to look at their online guidance, this thought has now percolated into their official published guidance. It was revised only as late as January of this year, so it reflects current thinking. And the phrase is regardless how small, any loss, regardless how small, is to be treated as having an adverse effect and therefore requiring IROPI if consent's to be given. Now, looking at where the law stands on this issue, the starting point is the Sweetman case, and there's a lot to be drawn from the Advocate General opinion of Eleanor Sharpton in this case. And at first it seems like plain sailing, because at paragraph 48 she says that there is a possibility in terms effectively of a de minimis type exception. I've provided the quote there for you, I shan't read it. And logic would dictate that although she said this in the context of considering whether there needs to be an appropriate assessment at all, considering, as she says in the paragraph, the significance, you'd think that logically that this would also apply at the appropriate assessment stage. No logical reason for it not to, particularly given the People Over Wind Authority, obviously, which says that when you're looking at that first stage of whether or not you need to move to appropriate assessment, you're not even allowed to consider the mitigation measures which you'd put in place. And one would tend to think that if mitigation measures had the effect of reducing any effect down to a de minimis level, that one ought to be entitled to, as it were, have the benefit of it at that stage. However, that's not really how Sharpton herself put it. Paragraph 60, she went on to say that measures which involve the permanent destruction of part of the habitat in relation to the existence of which the site was designated are destined by definition, she says, to be characterized as adverse. So what she was effectively saying there, it appeared, that any loss, once you've got to the appropriate assessment stage, that any loss of relevant habitat would be sufficient to throw you into adverse effects and therefore needing IROPI. And that's really, I think, where the caution of statutory authorities has come from in recent years, that particular paragraph. Now, it's quite important to notice, of course, that this is just the Advocate General's opinion. The judgment of the court is slightly more nuanced, perhaps, in that the judgment emphasized the consideration of favourable conservation status. Effectively, if favourable conservation status was being maintained, then some minor, aka de minimis, loss of habitat might be acceptable. And there was also a focus on whether the habitat being lost was one of those specifically identified as a priority habitat type in Annex 1, rather than simply a habitat which led in part to the designation of the European site as such. So a slightly more nuanced approach, but certainly that Sharpton paragraph is very much the fly in the ointment in terms of accepting that there be a de minimis exception. And so what, as I said, the judgment itself appears to lead us to conclude is that any loss of a priority habitat will be an adverse effect. Doesn't seem any way around that in the ECJ jurisprudence. With respect to non-priority habitat losses, that's a much more open concept, with a conflict in European thinking between the Sharpton fairly sort of rigorous approach, very wary of the danger of death by 1,000 cuts, and the more nuanced, perhaps more open approach of the court itself in the judgment. So that's the European position. The domestic position, and I'm going to go through this really quite quickly. There's a very useful natural England, forgive the typo, Natural England report setting out a consideration of where the law stood and where practice stood on small scale effects. And that reveals a much more open willingness to involve a concept of de minimis in our domestic considerations. And so if you look at, for example, English Nature's own guidance, which admittedly is somewhat dated, it's pre-Sweetman, that recognized the existence of de minimis. A number of cases, Morge in the Court of Appeal, Wealden and Smith, all recognize in one form or another the existence of a de minimis right, although it's probably fair to say that none of them as such really analyzed the European jurisprudence. I think it was almost taken as read that the concept of de minimis existed. And then we've seen the Secretary of State in a series of DCO decisions, and I set them out on the slide there. They'll all be familiar to the offshore wind community. But each of those, to one extent or another, recognized the existence, or at least again was able to rely on a notion of de minimis as one would now identify it. And I think that that was not something which was subject to part of the challenge in Norfolk Vanguard. And so one really arrives at a conclusion that the de minimis exception for habitat loss, it may exist in EU law, only may, but it does seem to have been accepted in domestic decision making, but rather on the basis of having been taken as a given rather than specifically analyzed. And so there is still the possibility, it seems to me, of a more frontal challenge based on that interpretation of EU law, to actually bring this to a head and see what the British courts think about it when it's actually put to them as a specific argument. Now, I mentioned the possibility of Brexit, their diminishing role for the European jurisprudence. We'll just have to see how things develop. So those are my thoughts on a couple of, I think, important but discrete aspects of environmental law. I'm looking firmly at the time. We've overrun a bit and people are disappearing off. We've got one question up there from Helen Mitchison, which I am going to need a moment to assimilate. Helen, what I'll do is I'll send you a written reply to that question, if I may, save everyone else watching me ponder. And all that remains, I think, to do then is to thank you all for your attendance. Thank Charles, Isabella and Mark for their very, very interesting contributions. And finally, to direct you to another part of FTB's environmental offering, which is our relatively newly launched environmental law blog. It was originally intended to be a commentary on the environmental bill going through Parliament at the moment, but that's taken so long that it's now expanded to be a very, very useful resource on all sorts of matters environmental, and I commend it to you, as they say. So with that said, thank you all very much for your participation this afternoon. I hope you found it useful, and we'll see you again at the next of our FTB webinars. Thank you.